subscribe now and press the bell icon. Never miss an update.
So let's start with today's case, Vijay Madanlal Choudhary versus Union of India. Okay, this is a recent case, and all of you know that this matter is again referred to a larger bench. Okay, so there might be there will be a judgment on this again, right? Because this has been sent for a review to the Supreme Court. So there will be a constitution bench discussing this case, maybe like in 2-3 months time. Okay, and this case is very important because they have been like daily there were articles on this in every newspaper. It has been debated a lot. There are a lot of concerns with regard to this judgment and all that. Okay, and that's why this case becomes very, very important from the examination point of view. So I'll try to complete this case in one class itself. This case is almost 555 pages, and it was a bit difficult to, make it this short. I was not able to do it, but I've only incorporated the important things that you should be knowing for your examination. All right, so let's get started. All right. So what was the background of the case? All of you know that this PMLA, which stands for Prevention of Money Laundering Act, it was formulated in 2002. And then after that, there were a lot of changes that has been made with respect to this act, right? And the background of this act is also important because they might ask you that which is the act enacted by India in response to Vienna Convention to combat the menace of money laundering, and that was PMLA, right? It was enacted in response to India's global commitment, which is given in Vienna Convention to stop or to prohibit the money laundering. Okay, so there are other conventions as well. So Vienna Convention is not just one convention, but it's an umbrella term for different conventions. So one of the conventions under it is United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, 1988. Second, Basel, the spelling is wrong. Okay, Basel Statement of Principles, 1989. Then 40 Recommendations of the Financial Action Task Force on Money Laundering, 1990. Then Political Declaration and Global Program of Action adopted by the United Nations General Assembly in 1990. So you need to remember all of these 4 conventions, which are also called as Vienna Convention, because of which we have enacted PMLA. Okay. Now, as I'm sure you all have been reading newspapers, and there's a controversy about this act. Why? This controversy is not surfaced this year, but this has been ongoing since 2019. Why? Because the amendment to this act was made through money bill, okay, by way of a money bill, right? It shouldn't have been done, but they made amendment to PMLA by way of a money bill. Money bill is a totally different thing, right? But still the government did that. And this controversy was dealt in Roger Matthew versus South India Bank Limited 2020 case. Okay. Even after this matter was referred to Roger Matthew case, it is still referred to a higher bench because that issue is not settled. The money bill issue, this amendment which came in 2019 by way of a money bill, they were not settled in Roger Matthew. And again, this issue has been referred to a larger bench. So in coming future, we'll have a judgment on this. Okay. Now the things stood as it is because there is no change even after Roger Matthew. Then petitioners filed multiple cases in different high courts regarding the application of this particular act, that is PMLA, right? And then Supreme Court agreed that if the Roger Matthew reference declares the amendment via money bill or finance bill unconstitutional, then all the debate provisions will go. Okay, but Roger Matthew didn't do that, right? Roger Matthew didn't decide anything on the amendments by way of a money bill. And that's why court said, had it been decided by Roger Matthew, the bill would have been considered as unconstitutional, but Roger Matthew didn't do anything. And the reference to this particular judgment is yet to be decided. right? And this particular case, that is Vijay, what is the name? Vijay Madanlal Choudhary, right? They discussed certain controversial issues which were raised by the parties. Okay, now let's, sorry. Now, what were the major issues before the court? Now, if you open the document of this particular judgment, it is very, very difficult. I must say it's extremely difficult to locate what were the issues before the court. The judgment is really haphazard. There's no index like you find in most of the cases, especially Divai Chandrachud justice cases. There is no judgment. Even at least they formulate certain issues in the beginning of the case, right? They hear the petitioners, respondent, and then they formulate the issues. But in this case, they did not formulate any issue at all. So it became a little difficult to find out what were the issues before the court. So the major issues before the court were majorly four. It related to bail, self-incrimination, burden of proof, search, seizure, and arrest. Okay, and why this case is also important? Because it has overruled two-judge bench judgment, that is Nikesh Tarachand Shah. All right. So as I kept mentioning this in the classes, that any judgment which changes the interpretation of law, any judgment which changes the law, any judgment which overrules the previous judgment, right, or any judgment which lays down a new jurisprudence becomes important for your examination, especially CLAT PG. All right. And that's why this is important, because it has overruled one of the judgment and it has given a very different interpretation of this particular act, which we will study, right? So what were the issues? Interpretation of proceeds of crime. Then if PMLA is a standalone code, right? Which means they went into understanding what is the interpretation of proceeds of crime. What are these proceeds of crime, right? Then they also, the issue was, if PMLA is just a standalone code, right? What is the period of attachment? How search, seizure, and arrest should be done, right? The burden of proof should be on whom, right? Then about bail in PMLA cases, then about self-incrimination, which is a contentious issue even after this judgment, right? Then legal compulsion to give answer, that connects back to self-incrimination again. Okay, so we'll discuss that. Now let's discuss the first issue, that is interpretation of proceeds of crime. Okay. Now, the proceeds of crime, what are the proceeds of crime? And this is the important ingredient to constitute the offense of money laundering. Okay. So if you want to charge any person with an offense of money laundering, the major term the court takes into consideration is proceeds of crime. Okay. And the court said that proceeds of crime needs to be constituted strictly. Right. Now, what are proceeds of crime? All the properties recovered or attached by the investigating agency in connection with the criminal activity, right, relating to a scheduled offense, right? Now, scheduled offense is that offense which is already defined in PMLA, right? Scheduled offense under the general law cannot be regarded as a proceeds of crime. So the property that is being recovered or attached by the investigating agency in connection with the criminal activity, right, to a scheduled offense, that cannot be regarded as the proceeds of crime. To be proceeds of crime must be the property that is derived or obtained directly or indirectly as a result of, right? So the emphasis on this particular word, as a result of criminal activity relating to a scheduled offense, right? So if they want to understand what are the proceeds of crime, then that property should be obtained. It could be obtained directly or indirectly as a result of criminal activity. And that criminal activity should be related to a scheduled offense. Okay. Now, for the proceeds of crime, the property associated with the scheduled offense must have been derived or obtained by a person as a result of criminal activity to the scheduled offense. And this distinction must be borne in mind while reckoning any property referred to in the scheduled offense as proceeds of crime for the purpose of 2002 Act. Okay. So this distinction is very important, right? The property should be obtained as a result of criminal activity, and that criminal activity should be there in the scheduled offense under the law. Okay. And if there are any dealing with such a proceeds of crime by way of any process or activity, that becomes an offense under Section 3 of the Act. So first step is to understand if there are proceeds of crime as a result of a criminal activity of a scheduled offense. And if yes, then dealing with that proceeds of crime becomes an offense under Section 3 of the Act. PMLA Act. All right. Now, this is the language of the court, right? I have reproduced the paragraphs of the judgment directly here so that, you read it. And just in case if they ask this in the examination, so at least you remember certain keywords and the, paragraphs, right? We have this visual memory wherein you read, you at least remember certain words, right? I'm explaining these paragraphs, but this excerpt, it's directly from the judgment. I mean, the diagram is not there. So some things here and there are my own, but the excerpts are from the judgment, right? So now what is Section 3 of the Act? It talks about offense of money laundering, right? Now see, they will not ask you exactly the wording of this particular section, but there might be a question with regard to which is that section which makes an offense of money laundering. Then that is Section 3. So it says, whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use and projecting or claiming. It as untainted property shall be guilty of offense of money laundering. Right? Now, this yellow portion, which I have highlighted, right? And I have also mentioned it here, the bold portion is the cause of controversy. Right? So only these words were the cause of controversy: use and projecting or claiming, which came through the 2013 amendment. Right? So what is an offense of money laundering? If a person, right, who knows that, these are the proceeds of a crime, but still he indulges into it, he keeps that property with him, he acquires it, and then he uses it and projects it as, as a clean property, or claims it to be his property, which is clean, which is white property basically, right? And he projects it as an untainted property, which means it's not a proceeds of crime, but it is own, good property. Then there is an offense of money laundering. Okay. Now, there are certain explanations given here for Section 3 that a person shall be guilty of offense of money laundering if such a person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly the party or is actually involved in one or more of the following processes or activities connected with proceeds of crime. What are these processes? So if any person who knows that, this property is from a scheduled offense or a particular crime, but still he indulges into it, right? He conceals it or he possesses it and he portrays it as saying that, no, this is an untainted property. He uses it, right? Then he will be charged under this particular offense, right? Now, the process or activity connected with proceeds of crime is a continuing activity. Now, why it is continuing activity? Because if you suppose if I have like cash in crores, right, and that cash is kept at my house, then obviously till the time all the cash is disposed of, that offense is continuing, that right? But even though it is disposed of, whosoever is in the possession of that particular proceeds, because that proceed is of a crime, right? And then it will be with him. Then also it will be continuing, because the subject matter, the proceeds of crime is itself is in circulation, right? And that's why it is said that the process or activity connected with proceeds of crime is a continuing activity. Even though if I disposed it off, it is going to be with somebody else, but that still remains proceeds of crime. That is not going to become, white money from black money. It still is a black money, right? And continues till such a time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted property or claiming it as untainted property in any manner whatsoever. So this crime or this process continues till the time any person is enjoying that particular property, the proceeds of crime basically, right? Now, so just a second. Yeah. Now, by and large, the debate is restricted to the discrepancy between the word and. Just a second. What happened? Yeah. So, by and large, the debate is restricted to the discrepancy between the word and, which features in the original definition, against the or in the newly inserted explanation in section 3. See, I'll show you again. Here is or. Okay, so this or has come in explanation after the amendment, right? And here it is and. Okay, here it is or, right? In explanation, understand this controversy. Okay, see here use, after use, they're saying and. Right? Here, concealment, possession, acquisition. If this is there, then there is or, right? If this first condition satisfied, then that's fine, right? But or use, right? So you can read this together. This has to be there, which means either it could be concealment, it could be possession, acquisition, or use, right? So from 4, there could be 1, 2, 3, or all of them, because there's a or condition. The second one says and, which means along with concealment, there has to be projecting or claiming, right? And how do you always understand and? It is the combination. I mean, you cannot leave one for the another. You have to take them together, right? That is there. But in explanation, they're using or, right? And that's why there's a controversy. See how clear that lawyer was. Right here, it is saying concealment or possession or acquisition or use or projecting as untainted property, or, which everything is in or. Even if one condition satisfied it becomes an offense. But under the main section, there has to be 2 things: concealment and projecting, or possession and claiming, or acquisition and projecting, or use and claiming, right? So that's the controversy. I hope that's clear, right? So the debate is restricted to this discrepancy between the word and, which is there in the original definition, against the or, which is inserted in the explanation under section 3. Now, while the stand of the government is that there is no requirement under section 3 to project or claim the proceeds of crime as untainted property. So government is saying that, no, there is no requirement, right? You don't have, I mean, it is not mandatory that you have to project that property as untainted property or claim that property as an untainted property, right? It is not required. Government is saying that. But the petitioners are claiming that this interpretation will be unconstitutional. Right? Which interpretation? The government is saying no, that and word is not mandatory, which means even if there is no projection, that is fine. But petitioners are saying no, this is unconstitutional. For the requirement is that not only does a predicate crime need to be committed, it in turn needs to generate proceeds of crime, and it must also then be projected as untainted property to qualify for the crime of money laundering. What is the requirement here for this offense? First, that crime should be a predicate crime, which means that the predicate crime is defined in that particular act. Okay, if you open that act, there is they have defined that these are the predicate crime. Now, suppose I have done a predicate crime, right? I have committed a predicate crime, but that predicate crime is not, that predicate crime has not given me any benefit or any profit or any money, right? Or any proceeds of that particular crime. I have not received any proceeds of crime. I just committed that predicate crime, right? Then it will not become an offense, right? To become an offense for this particular crime, predicate crime, to become an offense, right? It should generate proceeds of crime. And then that person has to project it, to show it to some other person or to the world that this is an untenanted property. Then only it will become a crime of money laundering. Otherwise, it won't. If there are no proceeds of crime, it's just a predicate crime, then it will not become a crime of money laundering. There has to be three things. Predicate crime must be committed. It should generate proceeds of crime. And then that person should project it as an untenanted property, right? Now, the general scheme of the law of this land is that any law which is questioned is presumed to be unblemished and within the confines of the constitutional principles laid down in the Constitution. This is the principle of constitutionality, right? So any law that is being made by the legislature, there is always a presumption of constitutionality, and that's what the court is saying. That's the thumb rule, right? But as the amendment was challenged multiple times, the court considered to examine Section 3 of the Act. Right? Court is saying we are in the favor of presumption of constitutionality, but since this particular amendment has been challenged multiple times, and that's why we're considering this particular challenge, and let's examine Section 3 of the Act. Now, this Section 3, which was there before 2019, prior to 2019, had itself incorporated the expression including. Okay, so this section prior to 2019 had this expression including, right? Now, which is indicative of reference made to the different process or activity connected with the proceeds of crime. So what is including? It means that there could be some reference to different process or activity that is connected with the proceeds of crime. Thus, the principal provision, as also the explanation, right, that is predicates that if a person is found to be directly involved in any process or activity connected with the proceeds of crime, must be held guilty of offense of money laundering, right? So if a person is found directly or indirectly involved in any of the process or activity that is a predicate crime and there is a proceeds of crime, then he will be charged with the offense of money laundering, right? Now, the court is saying if the interpretation set forth by the petitioners was to be accepted, it would follow that it is only upon projecting or claiming the property in question as untenanted property, the offense would be complete. Right? The court is saying if we accept petitioner's argument, petitioners are saying no, that person has to project that property as an untenanted property for an offense to be complete. Right? That was the petitioner's argument. And court is saying, suppose we accept this, right? If we accept this, yes, then it will become an offense. But this would undermine the efficacy of the legislative intent behind Section 3 of the Act. But court is saying, if we accept this interpretation of the petitioner, that as soon as that person projects or claims the property in question, saying that it is an untenanted property, offense becomes complete. That is not the legislative intent. Right? And also, this petitioner's view is in disregard by the FATF. What is the long form of FATF? Can anyone tell me? You must be knowing this.
Yes, anyone? Financial Action Task Force.
Yes, Financial Action Task Force. Thank you, Piyush. So this is Financial Action Task Force, right? So court is saying petitioner's interpretation is against legislative intent, and also it is in disregard in FATF, right? With the occurrence of the word and preceding the expression projecting or claiming therein. Okay. Now, court in Pratap Singh versus State of Jharkhand, 2005, right, enunciated that the international treaties, covenants, and conventions, although may not be a part of municipal law, the same be referred to and followed by the courts having regard to the fact that India is a party to said treaties. Now, since they mentioned FATF, Financial Action Task Force, obviously they have to back their argument, and that's why court is citing this particular precedent, Pratap Singh versus State of Jharkhand. Now, this is not only one case, this is a recent case, but we do have other cases which have talked about international treaties, covenants, and conventions, right? It says that even though these treaties, covenants, international covenants, treaties are not part of our municipal law, which means our domestic law, then the courts can refer to it. Why the courts can refer to it? Because India is a party to those treaties, right? We know that India is a dualist country. We are not a monist country, right? You might have studied about monist and dualist countries in your international law classes, and that is why we have, if we want any international law to be incorporated in our domestic law, then we have to first legislate on that under Article 253 and Article 51. Then only it becomes a part of our domestic law. But in monist countries, you don't have to, you don't have to make or create law in your country, but you assume that if that international law is there, that automatically becomes the part of your country. But in India, it doesn't happen. If there is suppose ICCPR is there, right, it will not become part or legislation for India automatically, because we are a dualist country. If you want to follow ICCPR or ICESCR, we have to have a law which is made by the legislature for our country, and that's why we are a dualist country. But courts can refer to these conventions and they can give the judgments. Similarly, there is another important judgment, Apparel Export Promotion Council versus AK Chopra, 1999, wherein court observed that domestic courts are under an obligation to give due regard to international conventions and norms for construing the domestic laws. More so when there is no inconsistency between them and there is a void in domestic law, right? So when courts can refer to these international conventions only when there is no inconsistency between the international law and the domestic law, and there is vacuum in domestic law. So to avoid that vacuum, they can refer to international conventions. Okay, that is being discussed in AK Chopra case. Same view has been restated in Geeta Hariharan, which is our famous case in family law, right? For Section 6. Also in People's Union for Civil Liberties and National Legal Services Authority versus Union of India, that is your NALSA case for right to privacy, 2014, right? Now, the explanation that was inserted in 2019 does not entail in expanding the purport or purpose of Section 3 as it stood prior to 2019, right? The explanation that is inserted in 2019, it is not expanding the purpose of Section 3. And but before 2019, the Section 3 was broader, right? And by inserting explanation, court is saying we are not expanding Section 3, which was there earlier, right? But that explanation is only clarificatory in nature. Okay. And this provision plainly indicates that every process or activity connected with the proceeds of crime results in offense of money laundering. ये provision बस इतना ही बोलता है कि जो भी आपकी processes है, activities है that are connected with the proceeds of crime, that becomes an offense of money laundering. Then projecting or claiming the proceeds of crime as untenanted property, when you're claiming, you're saying that no, this property is white property, it is not a black property in itself, is an attempt to indulge in or being involved in money laundering. just as knowingly concealing, possessing, acquiring, or using of proceeds of crime directly or indirectly. So court is saying, if you're projecting, you're claiming that these proceeds of crime are untainted, right? This is white money. This is not black money. If I'm saying that, what am I doing? Am I actually indulging into money laundering? Because I'm trying to hide something. I'm possessing that. I know this is a proceeds of crime, but I'm showing it, I'm projecting it, saying that no, this is an untainted property. That's it. Then it becomes an offense. Okay. Now, the act of projecting or claiming proceeds of crime to be untainted property presupposes that the person is in possession of or is using the same proceeds of crime, also an independent activity constituting offense of money laundering. Okay, so court is saying, if you are projecting the proceeds of crime to be an untainted property, मतलब आप किसी एक crime से आपको जो proceeds मिले हैं, जो property मिली है from a predicate crime, you are showing it to the world that this is an untainted property or this is a white money. There is a presumption, right? There is a presumption that the person is in possession of that proceeds of crime. And this is an independent activity that constitutes offense of money laundering. So same thing is being said by the court in different words. Okay. Now, in other words, it is open to read the different activities conjunctively because of the word and. Okay. If that interpretation is accepted, the effectiveness of Section 3 of the 2002 Act can be easily frustrated by the simple device of one person possessing proceeds of crime and his accomplice would indulge in projecting or claiming it to be untainted property so that neither is covered under Section 3 of the 2002 Act. Right? So, are you getting what court is saying? Court is saying, if we do not read word and, right? If we do not